Hello everybody, this is John DiMartino, Director of Productivity Coaching for the Waxman Group Productivity Coaching Program. And in this video, we're going to be discussing the exclusive right to lease listing agreement. As of the recording of this video, which is September 2023, this is the most recently revised version of this contract. This is approved by the Florida Association of Realtors and the Florida Bar. The contract is ERL-11, which was revised in March of 2021. So when would we actually use this contract? So we have a homeowner who wants to put his house on the market and rent it out to a potential tenant. That's when we're going to use this form in order to list their house. This is them officially hiring us. So now we're going to go into this contract. As always, this is a blank version of the contract, but we do have a pre-filled out version that you can use as a sample, and that's the one we're going to be going over right now. So without any further ado, let's go into the contract. So we always want to start to make sure that the owner, the owner that we're putting on the contract actually is the owner of the property, but has the authority to rent the home out. So the best way to do this is to go to the tax records and find out what the owner's name is. It may be one owner, it may be two owners, it may be an LLC or a corporation, but whatever is on the tax records, that is the owner of record, and that's who's going to be in this first paragraph. So in this case, we're saying Sally and Sam Sellers. They're the owners. They're going to be the landlords. So they're hiring Keller Williams Realty Consultants, Realty Professionals, or Keller Williams Elite Properties, depending on which brokerage you're working with. But they're hiring the broker. They're not hiring John the agent. They're not hiring you, the agent. They're hiring the broker. Now, we are the authorized sales associate to handle the listing, but the owner is hiring the broker. So it's important that we put the broker, the full brokerage's name where it says broker. So in paragraph 1, this is the time frame that the owner is hiring us to list their house. Typically, most listings are going to be 6 months long. Now, one of the things that I do for my business, and this is a best practice, is I have all of my contracts, whether buyer brokerage agreements or listing agreements, I have all my contract expire on the last day of the month. I don't like surprises. That's I don't have to be worried about a contract expiring on me in the middle of the month. So I do have all my contracts end on the very end of the month. So for this example, we're saying that the 20th day of September 2023, I'm going to go 6 months out, and we're going to say the contract is going to expire on the 31st day of March 2024. Okay. As we go down to paragraph 2, this is the description of the property. Remember, we said in other videos that a home has 2 addresses. There's the street address, and then there's the legal description, which is the official description of the property as it is recorded with the county. So the property address, we're going to put the street address, 123 Main Street, Anytown, Florida. Don't forget to put the zip code as well. And then for the legal description, you're usually going to get this from the tax record. So go to your tax record, your county tax records, and find out what the legal description is. And we're going to put that over there on paragraph 2A. Okay, so if there's any personal property that is going to be included in the rent, whether the home is furnished, whether they're including other things, the boat that's out back, anything that is considered personal property, things that are not fixtures, not appliances, any personal property, if it applies, we're going to go ahead and mark it over here in paragraph 2B. Paragraph 2C is what is the occupancy of the vehicle, of the property right now. Is the property currently occupied by a tenant? Is it currently vacant? Who lives there? Is it the tenant or the landlord? So we're going to make sure we put that in here as well. If the property is occupied by a tenant and there's an active lease that's in place, when does that lease term expire? And we're going to put that onto the listing agreement as well. Paragraph 3, this is going to be the terms of the listing, including the rental price and what the landlord is asking for. So in this case, for paragraph 3A, we're saying that the monthly rent in this example is going to be $2,500 a month. The owner's asking $2,500 a month, and he's also asking for first month, last month, and security deposit. So we're going to check over here. We're going to check over here that he's asking for the first month. We're also going to check, and I see that I didn't do it on this example, so I do apologize, but the advance month, which is the last month, we're going to check that as well. And he's also requesting a security deposit in the amount of $2,500. Okay, now the security deposit, we do have to put who's going to be holding that security deposit, and it could either be the owner or the broker. Now, our broker does not hold security deposits for rentals, so it is required that we're putting that the owner is going to be the one that's going to be holding that security deposit during the term of this lease. Now, if it is going to be held by an owner, is it going to be held in an interest-bearing account or a non-interest-bearing account? There are regulations and rules and laws that say if a security deposit is being held in a interest-bearing account, that the tenant should be receiving some sort of interest on that amount. If the owner is going to be benefiting from it, that the tenant will also get some of that interest as well. For the most part, and it's advisable that the owner is going to hold it in a non-interest bearing account. If the owner is going to be requiring a pet deposit, is the deposit refundable or non-refundable? And they're saying $250. Is that $250 total, or is it $250 per pet? All right, we do want to make sure that we're specific in here, because when we do get tenants that are sending us offers, we want to make sure that we can speak on behalf of what the wishes and desires of the owner had when he initially listed the house with us. Credit report fee. We're only going to check this if we are the ones that's going to be pulling the credit report. For the most part, what I do for my business, I tell and I put in the MLS that if there's any tenants along with their contract to lease, I want them to send me a credit report with the credit score. I want a background check. I want an eviction report. I want a rental application and all these other documents, including a copy of the driver's license or a photo ID of all adults that's going to be living in the home, and income statements for the last 2-3 months so I can verify that they'll be able to afford the $2,500. I do not pull the credit reports. I have them pull it, but I do want to make sure that the rental reports or the credit reports that's being pulled is from a reputable source, that there's a score, and that it's recent and it's up to date. If there's an association application, all right, we do want to find out if there's a fee for doing so and for applying, and if so, we're going to put that in here as well. Now, some cities or shorter lease terms will require state tax to be paid, so we're going to want to make sure we're putting that in here if that's the case. If not, we're going to move on to paragraph 3D, which is about association approval, and specifically, when must the tenant submit the application? Okay, well, this one actually says association approval, and it was put on here 5 days 5 days before move-in, but it actually should say 5 days of effective date of this contract, because we do want to make sure that they have applied and there's enough time for the association to make their decision before closing, and that way there would be no delays or anything. Okay, so let's discuss what the broker obligations are when we're working a rental or a rental listing. The broker obligations. The owner is giving permission to the broker to obviously use diligent effort to lease the property, to post it, to advertise it, to negotiate on their behalf, as well as some other following activities. These activities that I'm going to recommend that you check off, and this is what I do in my own rental listings. I check the first one, says display appropriate transaction signs. So that means that we may put a for rent sign on the property. Make sure you check with your association or your city to see if we're not allowed, if the owner or anybody else is not permitted to put any signage up. We do want to make sure we're complying with that. I also always put on that we're to check this third box. authorizing us to use a lockbox on the door. Now, I always use a super lockbox. The super lockboxes is the blue box that the agent has to put in a code. There's a CBS or a confirmation code that's for additional extra security. However, the super lockbox is the most secure method for housing a listings keys. All right. If you use a combination lockbox, you can use that. I don't recommend it because any agent, maybe there might be an unscrupulous agent out there that might just tell their potential tenant, go to the house, the combination is 1, 2, 3, 4, and now that combination was leaked to someone else, and there's no way to track it. But with Supra, there is. Everything could be tracked. So I do usually check on here to authorize that the owner authorizes us to use a lockbox on the house. We're not going to check the execute leases on behalf of the owner, okay, because that would require a power of attorney. We're not going to do that, all right? However, what we will do is complete lease forms as permitted by law. Now, there is a website that I use when it comes to creating a lease, and I'm actually going to pull this website up right over here. This website is going to be evict.com, and this is the law offices of Heist, Weiss, and Volk. Now, I do recommend, this is the company that I use for all of my rentals, my rental listings. This is the company that I use, that they will write, these are attorneys, and they will write the actual lease. They will prepare the actual lease for a cost of about $40 to $50, and they will enforce their own lease as well. But you can find them at evict.com. Now, there are other options that you can use. There's Florida Association of Realtors has a lease that can be prepared by the agent. The reason why I'm not crazy about that lease is it's not very clear and it's very vague on a couple different things, whereas the lease that we get from evict.com is very cut and dry. It says this is what can be done, this is what cannot be done, and if there's an issue, this is how we resolve it. Again, that's going to be your decision of what you want to do, which lease you want to use. I prefer to use the one from evict.com, but you're also able to use the FARBAR residential lease as well. Okay, so I do check complete lease forms as permitted by law, and I'm also going to check that we're going to compensate any sub-agents or cooperating brokers, except in a situation where it's not in the owner's best interest. So we're going to talk about commission as we go into other paragraphs, but the owner is authorizing us to make sure we're compensating them as well. As far as for advertising, paragraph 4A is about advertising the property. The home is going to be included on the internet unless the homeowner requests that it is not, or instructs the broker to not advertise the property on the internet or use the address while they're marketing and advertising the home. If that's the case, they would check here, and that would be, they do have to, the owner will have to sign acknowledging, right, that they may not see the information on the MLS or the internet if they're not using that. It's very rare. I've never seen it happen. So most of the time what I do is I just skip this section, and I did put on here do not complete or sign, because it'll actually be counter to what you or the landlord would actually wishes to do in most cases. The next paragraph talks about valuation sites. If we were to check the first one, that is not, the automatic valuation site is going to be like a Zestimate on Zillow. And if we check the first one, we're saying we do not authorize those companies to put an estimate of market value on the property. We're saying, no, you cannot put a Zestimate next to our rental price. I usually don't check that one. I'm perfectly fine with having a Zestimate over there. But I do always check the second box, which says that the owner does not authorize third parties to write comments or reviews about the listings about the property anywhere on the internet. So I do make sure I check that one. Both of those are options on the MLS when you're entering it into the MLS. It's going to ask, do you want to post it on the internet? Do you want to use the address? And do you want to allow blogging or third-party comments? Okay, so that is the broker obligations. Let's talk about what the owner obligations are. So in consideration of the obligations of the broker, which is everything we spoke about already, the owner agrees to obviously cooperate with us in carrying out the purpose of renting out this property. If they hear of anybody that's looking to lease the property, to come to us and give us those inquiries so that we can handle that. They're going to give us a key to the property, and in this case, I only put one here. We only need one key so that we're going to show the property using that one key. Once we get to closing or to lease start date or move-in date, at that time, I'm going to ask for the additional keys, a garage door opener, mailbox keys, pool keys, etc. But for advertising the home, I only want to get that first key. I don't want to run the risk of somebody or anybody, or worst case, myself, losing that key, extra key. So I only want to get that one key. Okay. If there's anything about the property that needs to, that's not visibly available, that could change the value or the price of the home, they have to disclose it. The owner has to disclose it. So they would let us know if anything happens. If they decide to sell the house or convey the house or rent the house to anybody else, that they're going to let us know. So that way, again, I don't like surprises, and I don't want to find out right before I put a tenant in there that he's now also listing the house for sale or already under contract to sell it to somebody else. Okay, so these are some of the owner obligations. That's the owner obligations that is in here. So now let's talk about compensation. This is going to be the commission that we are going to earn as the listing agent for the rental, and we're also going to talk about in the next paragraph how we cooperate with and compensate the other broker that's going to bring the tenant. Okay, so in most cases, rent is either going to be, the commission for rent is either going to be one of two ways. It can either be 100% of the first month's rent, so commission would be 1 month of the rent, or it would be 10% of the gross value of the lease. So 2,500 times 12, and then 10% of that. That would be what the commission is, and then whatever portion you negotiate with the landlord will be split with the other party. In most cases, that's going to be 50-50. So 5% of the gross lease would go to the listing agent, 5% would go to the tenant's agent, or half a month of the rent would go to the listing agent, and the other half of the month would go to the tenant's agent. So we're putting up in here in paragraph 6A, we're checking this box right here and saying that 100% of the first month's rent is what's going to be owed to us and owed to the broker for commission once we actually rent this property. And that first month's rent, that commission is going to be deducted from any fees that's collected by the broker. Okay, and so the commission is going to be coming out of the money that we're already collecting. So an example of this would be a tenant will go ahead and put a 1 month deposit, or a good faith deposit with their broker or with our broker. So they're going to be holding that, which would be applied to the first month's rent. However, as we get closer to right before closing, we're going to request that check that we're holding, or have the other broker request the deposit check that's being held, and half of that will be, or the commission that is due will come out of that money. The rest of the money will either go to the co-op agent, or it's going to go back directly to the landlord. Okay, it's a little bit confusing because we're taking a deposit. It's going to become the first month credited towards the first month's rent. However, we're taking our commission from that deposit that's being collected. Okay, so it's a little bit confusing, but just know that's kind of what usually happens. In some cases, the landlord will say, no, commission is not to be paid out of the first month. That's going to come from another, that's going to be in a separate check. And then you got to put that in here on one of these other check boxes of when that commission, when the owner will pay the broker's fee. Okay, so it's very important that we put that in here as well. The protection period. Owner agrees to pay the broker fee within 180 days after the end of the listing period. Remember, as we said, this one says we're going to end in the end of March. So for the next 180 days, the owner agrees to pay the broker if it's leased to anyone that which we brought them to the property. Okay. Now there's some other things that's going to go, other nuance that will go along with this. If you have a rental lease and it's about to expire and this protection period might become a factor, contact your broker, contact your coach, and we'll discuss exactly what that is. For the most part, what I tell my sellers and what I tell my landlords is, if I'm bringing someone to your house to rent them, rent it with me, even after this listing agreement closes, because we did a lot of work in order to find someone, and we don't know if that person that came to the that new tenant that found your home was a result of some of our marketing efforts. Okay, if there's an issue with that, contact myself, contact our broker. Paragraph 7 is about cooperating with the other agent. We do, in order to put it in the MLS, we do have to specify on the MLS how much that we will be compensating to the tenant's agent. In this case, we're saying that it's going to be 50% of the first month's rent. Remember, I said here we're collecting 100%. However, 50% will be going towards going to the other person, the other party. Conversely, if we were to have 10% of the gross value of the lease up here and we were going to send 5% to the co-op agent, we'd mark that over here as well. Now, it does say in here, and this is, I did kind of break this up, but it's worded a little bit strange because it separates it between the commission to a single agent, a commission to a transaction broker, or the commission paid to someone who has no brokerage relationship with the tenant. For my business, I always offer to pay commission to anyone who is working as a single agent for their client, or anyone that's working as a transaction broker. If someone has no brokerage relationship with their tenant, I'm not obligated to pay them a commission. However, I am putting that in the MLS. I do have that on my on the listing agreement, so I'm putting that out there that there has to be some kind of brokerage relationship in order for me to pay them compensation. So paragraph 8 is about early termination. So if the owner decides to not rent out the property for whatever reason, and they want to cancel the listing agreement, all right, is there a cancellation fee? For my listings, I usually do not charge a cancellation fee, so I'm going to make sure I put 0 here, and I'm also going to make sure when we're going over this contract with the owner that I'm pointing out to them that we will be doing it and not charging a cancellation fee at all, and I'm going to make sure that they see that I'm putting in 0 cancellation fee over there. If there is a dispute, if there's a dispute between any of the terms of this contract, we agree to go to mediation. Usually after mediation, it would go to arbitration, and if anything cannot be resolved to arbitration, then it would go to court. Our broker says we will not go to arbitration. Our broker does not agree to arbitration. So he's saying we can go to mediation or we can go to court, but we're not doing arbitration. Now, the reason for that is a decision that's made during mediation is not necessarily binding. And a decision that's made by a court is binding. That is formal, that is final, that is what it is. And with arbitration, this is not a judge who is the arbiter during the arbitration case. However, whatever decision that they make is final, is binding. And our broker says, no, we will not do that. So because we're opting out of arbitration, okay, we are not going to have them initial, all right? We're not going to complete this paragraph 9 section. We're not going to have anyone initial and sign. If for some reason they did sign, our broker does have to actually initial here as well. We're the listing associate. However, only for here, for dispute resolution, our broker would have to initial here as well. Paragraph 10 is going to go into the brokerage relationship. What is the relationship that we will have to the landlord? We can work as single agency and single agent as a single agent for them, working in single agency as a fiduciary. We can work as a transaction broker, meaning we're the middleman between the tenant and the landlord, or we can work in single agency with consent to transition to transaction broker. That's the one that I use on all of my listings, all of my buyer representation agreements, and on all my contracts. I state that I'm working for the owner or for my client as a fiduciary for them, and they're giving me permission to become a transaction broker if I'm representing both sides of the transaction. Okay, so that's, you do have to spell out with a relationship that we choose to work with that client. Paragraph 12, if there's any additional terms or anything additional agreements that we want to make part of this contract, we're going to go ahead and put it here in paragraph 12. If there's not anything, we don't need to write anything here, but if we do decide we're going to put additional clause, speak regular English. There's no reason to try to speak lawyer speak. We're not attorneys. We shouldn't try to pretend we are by speaking fancy. Just say exactly what you want to say, the terms that you want to say, and that should be it. Just so it's nice and clear and easily understood. Okay. Now, as all of our contracts, it does state that we are not attorneys. We're not giving legal advice or tax advice. And if they do not understand anything that's in this contract, that they should speak with an attorney or a tax professional, and that's going to fall back on them. But that is us disclosing that to them. So we complete this form. Okay. Usually what I do is, if I'm going on a listing agreement, I'm going to prepare this form almost in full, with the exception of the rental amount, okay, and the dates that they're hiring me. Now, when I go there, I'm going to try to negotiate the rental price or the listing price. And another thing I'm also going to put in here, first, last, and security, that is a suggestion. It's not what is set in stone. I usually do first month and 2 security deposits. In that case, it would be $2,500 for security deposit. I'm sorry, $2,500 for first month and $5,000 for a security deposit, because that's counting as 2 security deposits. If they're going to be paying, if the owner's requiring advanced month's rent of 3 months, we're going to put that over here. But we're not going to find that out when we're preparing for the listing presentation. We're going to find that out when we're sitting at the living room table with the tenant or with the landlord, going over the terms that they want for their rental. So first, last, and security, or first and 2 months security is what is most common, usually what we see. So they agree to hire us. We agree to all the terms. We're ready to get started. We're going to have the owner make sure that they are signing. If there's multiple owners, both of them are going to sign. Remember, they're going to initial at the bottom of every page, and so are we. We're going to sign initial at the bottom where it says sales associate. We do want to make sure that we're putting the contact information for the owners and for the authorized sales associate. So we want to make sure we're putting in the cell phone number, your cell phone number, the brokerage address, and your email address, as well as the landlord's telephone number, email address, and mailing address. Okay. This last section right here is highlighted because in order to make this contract, or listing agreement become a fully enforceable contract and fully executed, we do have to make sure that all parties that receive this contract or that sign the contract receive another copy of it. So usually, if we're signing this through DocuSign, once they sign, they will automatically receive an email copy of the fully executed contract. If we're signing this in person, we can go ahead and just write the date that this will be sent back to the owner, and check, is it going to be done by personal delivery or email, or if we're going to be dropping it off in snail mail. Okay, if we're going to be checking personal delivery, I do request as a best practice that you have your client initial next to it, marking that they did receive this contract. The last thing we want to happen is there to be a dispute dispute that goes to court, and all of a sudden a savvy lawyer will turn around and say, this entire contract is not enforceable because a copy of the signed contract was never returned to the owner. A judgment would officially be made, most likely in favor of the landlord, because this is a non-enforceable contract. Make sure that all the T's are crossed and all the I's are dotted, and that we're returning a copy to the owner. Okay, so that is the end of the exclusive right to lease listing agreement. The next step would be to put it into the MLS under residential rental. That's going to be for another day or another video. If you have any questions about this contract or any other contracts that were complete, feel free to reach out to myself, reach out to your broker, or any of the coaches at any time. Congratulations on filling out a listing agreement for a sale or for a rental. It's always great to know that we're taking a market share. Thank you very much, everyone, and have a great day.